Good morning, everyone. Welcome to today's webinar, a webinar which is organized by Chandigarh Judicial Academy in collaboration with SCC Online. Today's webinar on wills, execution and proof by Justice Rajive Bhalla, sir, who's a former judge of PNH High Court. First of all, thank you so much, Rajiv sir, Lordship, that you've taken out time and you will be sharing your experience with us. I was talking to sir and sir was giving me all the insight about how it's going to be going. So all I can say is very well structured. And like I always say that, the queries that you might have, will obviously, I think 90%, 99% of the queries get resolved because of the speakers that Chandigarh Judicial Academy brings in. And sir needs no introduction. However, as a courtesy's sake, I would like to give a small piece of, introduction for sir. Sir is a blend of a lawyer and a judge. He joined the bar in 1978, practiced on the civil and the constitutional side. Sir was elevated as the judge of PNH High Court in the year 2004, and he was retired in 2016. He is more active and regular with Chandigarh Judicial Academy and presently a Dean Faculty of Law in Guru Nanak Dev University, Amritsar. He's also a practicing advocate in Supreme Court of India. Sir being so instrumental, and I think now we know because sir is also into academics, is still practicing law. So I think this session gonna be a great session. So without any further ado, I would like to first convey my regards to sir and request sir to please take it over and bless us with his wisdom. Sir, over to you, sir.
Thank you, Mr. Gill, and thank you for that profusely, what would I say, flattering introduction. A lot of the people sitting here may know me, but now there'll be lots who don't know me because it's been 4 years since I retired. So without much ado and without any further greetings or any further these things, I just wish everybody good morning and hope I'm able to get you into the depth of a topic which we framed, which basically pertains to the execution of a will and the proof of a will. I think most of the audience has, and definitely it's almost on a daily basis, that the question of proof of will comes before you in a civil suit. So I'll just start by a brief introduction of what is a will. You all know it. I don't have to introduce you, but since I've got to take you through the topic, it'll be appropriate for me to just briefly give a will. A will, as you all know, is a document executed by a man when he's alive, but which speaks after his grave. I'm sorry, we don't have many graves nowadays, but it speaks from his grave. And it determines the course of succession to his properties, both movable and immovable. A will, by its very nature, is meant to exclude some people or determine the course. And therefore, the mere fact that somebody is excluded is not sufficient actually to eventually set aside a will. That I'll come to later. So what happens is the will, we have an act that governs the execution of the will, and you all know it. It's the Indian Succession Act 1925. So can I just take you straight to the definition of a will? Section 2H. Would you just put up section 2H?
I'll just share my screen. So
Indian Succession Act 1925.
So it's on the screen, sir. Oh no, not no.
You'll have to change the page.
I have to share this page for everyone to see it. Just a minute, sir.
Okay. In the meanwhile, before Mr. Gill puts up the definition of will, there are certain expressions which are necessarily to be used, but unfortunately don't get used are the executor of the will, or which we all end up pronouncing it executor. It's not executor, it's executor of the will, is in 2C. Uh, Probate is in 2F, and will is in 2H. So if it's not been put up, I can just read it out quickly. Will means the legal declaration of the intention of a testator. Now the testator is the person who's executing the will. A small request to everybody that please use the word testator in your judgments also, instead of executant, which is a word used very often by many of us. And I'm saying many of us, I'm including myself so far as long as I was a judge. With respect to his property, which he desires to be carried into effect after his death. So it is the intention of a testator with respect to his property, which he desires to be carried into effect after his death. Now, this intention has to be very clear and it cannot be ambiguous, and it must relate to some property, whether movable or immovable. That is the definition of a will. So, from straight here, a question would arise that what is there any format prescribed for a will? Is anything prescribed under the Act as to how a will is to be executed? What is the execution of a will? And then I just refer to a word called probate in 2F. If you can just put up 2F.
So 2F. So it is on screen now.
Probate means copy of the will certified under the seal of a court of competent jurisdiction with a grant of administration to the estate of the testator. Now, something very clear over here that this does not apply to Punjab and Haryana. In Punjab and Haryana, you need not seek a probate. You can straight away either go to the authority for entering a mutation. If it does so, well and good, or you can file a suit. This is prescribed in section 57. Can you just put up 57?
So
you'll have to move the. May I just read it? The provisions of this part, which are set out in Schedule 3, shall, subject to the restrictions and modifications specified therein, apply to all wills and codicils made by any Hindu, Buddhist, Sikh, or Jain on or after the first day of September 1870 within the territories which at the said date was subject to the Lieutenant Governor of Bengal or within the local limits of. Can you just move it up?
So is it visible?
Ordinary civil jurisdiction of the High Courts of Judicature of Madras and Bombay. So these were the three presidency towns. Anybody residing there would be required to seek a probate of the will. But anybody outside does not require a probate. Yes, if the property is situated there in these, then you would also require a probate, even if you are situated outside. With reference to this, there's a section which excludes it, that's section 213. Can you just please put on 213?
So.
Of the Succession Act. No right as executor or legatee can be established in a court of justice unless a court of competent jurisdiction in India has granted probate of the will under which the right is claimed, or has granted letters of administration with the will or with a copy of authenticate copy of will annexed. These sections shall not apply to cases of wills made by Mohammedans, Indian Christians, and shall apply only in the cases, I'm skipping it quickly, 57A and B. I've read it already. 57A and B is persons and properties situated within the three presidency towns as Calcutta, Madras, and Bombay. So if you are situated within the jurisdiction of these high courts, even now, you would require a probate, otherwise you would not. Otherwise, the only course, like in Punjab and Haryana, is that you apply to the revenue officer for a mutation. And if he doesn't agree or if you're not satisfied, then you file a suit for declaration. So can we just now quickly switch to, and please, my request is everybody keep his questions ready because there'll be lots of them. I'm right now only taking you through the basic fundamentals of the Act. Now, can we come to section 59? I think we skipped 59.
Yes, we did. So there it is.
Section 59, every person of sound mind, not being a minor, may dispose of his property by will. We can exclude one explanation one because this is no longer relevant. Originally, there was a time when a married woman, there were different rights. Only if she had the right to alienate could she make it. So this is no longer now because now it's an absolute property of the woman under the Hindu Succession Act. And now we've even gone a step further. She's even become a co-partner. Persons who are deaf and dumb or blind are not thereby incapacitated for making a will if they're able to know what they do by it. This is a very important provision. In fact, this is in consonance with the Persons in Disabilities Act also, though this was made in 1925. So a special provision has been made that you have to ensure that they're not incapacitated from making a will. Why is this? Because as we'll go later, and in fact, you all most of you know it, deaf, dumb, or blind. How will a person who's deaf put his mark? I mean, read it, or dumb or blind. How will he put his mark on a will? This is a question which will come up for consideration. A person who is ordinarily insane may make a will during an interval in which he is of sound mind. I can give you an example. People are schizophrenic. A person who's schizophrenic is not necessarily insane all the time. There are bouts of schizophrenia, and therefore, if during that period is executed a will, it will not be illegal for the fact that he suffers from some sort of an insanity. No person can make a will while he is in a state of mind, whether arising from intoxication or from illness or for any other cause, that he does not know what he is doing. So these are important things. Unfortunately, when we are looking at a suit, we somehow tend not to read these sections. We all move from perceptions of what the law is. Now, these are illustrations. I request you all, when you have a little time, I know you're all very hard pressed for time always. You're meeting deadlines of your judgments, everything, but please just go through this a little. It will help you to understand a few things and maybe sometimes correct perceptions that we have developed over a period of time. Now, can we just go straight to from 59 to straight to 61?
So,
Though this will come in later, 61, but there's something I want to explain over here. A will or any part of a will, the making of which has been caused by fraud or coercion, that you all understand, or by such importunity as takes away the free agency of the testator is void. This word importunity is a word we very, very rarely use, or is a circumstance which comes very rarely. This is a word which means that when you harass a person or you continuously so harass a person that he's left with no option but to eventually give away something to you so as to stop you from that harassment or that continuously heckling him for things or things like that. So this is the meaning of that word, where you eventually lose your mental balance to be able to judge whether you should do it or you just want to get rid of the man who's trying to get after you all the time. So this is the word. So, and please, these are the illustrations. Now, since it's a rather longish subject which we've taken, instead of concentrating on one, there are two types of wills in the Act: a privileged will and an unprivileged will. Most of the wills we execute are unprivileged. Privileged wills are executed by people in the Army, Air Force, Navy, or the armed forces. So we will not deal with privileged wills. Those privileged wills came in because when the British were in this country, they had their armed forces, and normally their people were in India and their families were in England. So they put this into place called an unprivileged will, where the army, it would be executed and the normal process would not apply. So even the commanding officer would attest the will, and that would be deemed to be a proper will, because he could be at a border and not able to attest a will. So that's privilege. Now unprivileged wills. Can you just put up section 63?
So,
Every testator, not being a soldier, employed in an expedition or engaged in actual warfare, that means that's privileged will, or an airman or employed or engaged, or a mariner at sea, shall execute his will according to the following rules. This is a section which you deal with almost every day or every second day. And almost all disputes regarding wills relate to this section. And of course, this is special circumstances, etc. The testator, that's the person who's executing the will, please request you all to start using the word testator, shall sign or shall affix his marks on the will, to the will, or it shall be signed by some other person in his presence and by his direction. Now, mark can mean his thumb impression, anything else he feels like. The signature or mark of the testator or the signature of the person signing for him shall be so placed that it shall appear that it was intended thereby to give effect to the writing as a will. I think you all understand what this means. That it must be placed towards the end of the will and at a place where it would show. Normally, normal in a writing is the person signing on the right hand of the will. But there's no prohibition in his signing in the center. But generally, when he signs on the left, there does arise a question as why did he sign on this side? And as you all know, there is always people have signatures on blank papers are taken in during many proceedings. So eventually, all this indicates the fact that the placing of the lines, the spacing, the this is where it is written that this is how it must the signature or mark shall be placed that it shall appear that it was intended thereby to give effect to the writing as a will. Now, why I'm emphasizing on this is always we as judges, all of us who have been judges or who are judges, do not quote these sections when we say that the signature is not at the right place or that the spacing is not correct. This is one provision which I personally feel, lest I leave it to all of you, you are all judges in your own right. We should start quoting these provisions because that's how you carry the understanding of the law further. There'll be some youngsters amongst you, some people who are experts in the law, who have been doing it all their life. But still, I think these are provisions you need to start using. Can you just take the next one? C. Can you put up C,
so
Mr. Gill?
can you see it, sir? It's already on the screen now.
Oh, I can't see it.
Might be a lag of internet.
It's here. It's come.
So.
Now, this is the will shall be attested by two or more witnesses, each of whom has seen the testator sign or affix his mark to the will, or has seen some other person sign the will in the presence and by direction of the testator, or the received from the testator a personal acknowledgement of his signature or mark, or of the signature of such person, and each of the witnesses shall sign the will in the presence of the testator. But it shall not be necessary that more than one witness be present at the same time, and no particular form of attestation shall be necessary. Now, these are very quick. The first part is very simple. In the presence of, you should see him putting his signature or mark. But there's one part which sometimes leads to some dispute. But it shall not be necessary that more than one witness be present at the same time. So the question arises, if more than one witness is not present at the same time, then how does the testator sign in the presence of the witnesses? The section itself contains a provision that or has received from the testator a personal acknowledgement. Can you highlight this part, third line onwards? Or has, third line of C, or has received from the testator a personal acknowledgement of his signature or mark. So I hope that is clear. So this indicates that both witnesses need not be present at the same time. But if they are not present at the same time, then the witness who comes later, because the document has already been signed, he will not sign it again in the presence of the second witness, must receive an acknowledgement of his signature or mark. His signature or mark points to the testator. So if the two attesting witnesses are not present together, then the second attesting witness must receive a personal acknowledgement of his signature or mark. This is where the execution of a will comes in. So in that situation, it would be advisable for a person executing such a will to have a little recital at the bottom of the signature of the testator, that though they did not sign at the same time, but the testator acknowledged his signature on the will to the second test witness, who signed, thereafter signed in the presence of the testator. But normally this is missing. I've still to come across a will with such a recital, and therefore it leads to a lot of problems in this. Now, attestation is not defined under the Indian Succession Act, but attestation is defined under the Transfer of Property Act. Mr. Gill has forgotten to write transfer.
So,
can you just put it up?
I will just put it on the website itself straight away.
So please, anybody has any questions on C, please keep them ready. I'll answer them. I'm just rushing through the entire thing. So these are things almost everybody knows.
Section 3 or section 30?
Section 3.
3, so. So is it visible on the screen?
Yeah, it is. You'll have to slightly attested is the third point of section 3. In relation to an instrument means and shall be deemed always to have meant, attested by 2 or more witnesses, each of whom has seen the executant sign or affix his mark to the instrument, or has seen some other person sign the instrument in the presence and by direction of the executant. It's the same words which are used under section 63C. So sometimes when you're in a mood to decide on attestation or what to write about attestation, you can use this interpretation clause attested, because this is not just for the purpose of Transfer of Property Act. This is for everything, because a will is also a transfer of property, though excluded from the Transfer of Property Act. Now we come to, you can use the word registered also is here, which will come later. Now, why is there's a small debate that goes on always, that why is execution of will, which is also a transfer of immovable property, not included in the Transfer of Property Act? The answer is right in front of you. See the definition of the word instrument means a non-testamentary instrument. A testamentary instrument is a will which devolves property after the demise. So that is why the Transfer of Property Act relates to instruments which are all right. So that's why it's excluded, and it moves only into from the Indian Succession Act. Now, the problem with this online thing is that you don't have a reaction. So it's very difficult to figure out what is happening and what is not happening. But I'll wait for the.
I think it will all come in one big blow once we have the question answer.
That's what happens. It always happens like that, and then lots of things get left out.
So
okay. Now we come to
Evidence Act.
No. Some very important things which we may have read in law college, or we may have read once in a while, but we don't refer to them in our. Can you just take them straight to section 71
of Transfer Property Act or
Succession Act?
Succession Act. Okay, sir. So it's on the screen now, sir.
See, in lots of wills, You say that there are cuttings, underlinings, overwritings, changes which are not signed, but we never refer to the section. This is the section in the Indian Succession Act. No obliteration, interlineation, or other alteration made in an unprivileged will after the execution thereof shall have any effect except if so far as the words or meaning of the will have been thereby rendered illegible or undiscernible unless such alteration has been executed in like manner as herein before is required for the execution of a will, provided the will as so altered shall be deemed to be duly executed if the signature of the testator and the subscription of witnesses is made in the margin or on the same other part of the will opposite to near such alteration, etc. What I'm trying to say is this is the jurisprudential basis for your findings that there are cuttings which are not signed, there are cuttings which are additions which are not signed, neither by the witnesses nor by the testator. So this is your jurisprudential basis and start and from where you should, in my opinion, when you're dealing with such things, refer to section 71. But more often than not, since we are always in a hurry, this somehow gets left over. I have never used it, and I don't know if anybody's ever made a reference to it. Now, wording of a will, 74. A will can be worded in any manner. There is no particular magical formula, no particular format, no words, technical or words of art that have to be used. I can write a will, just a one sentence will, that I am the owner of property in Punjab and Haryana. All my property go to person A. All I need to do is to sign it, have it attested. It'll be a valid will. I don't have to write, I am an old man of 70 years old. I don't know when I will die. Life is so uncertain, which almost all lawyers have a habit of writing. Everybody has a habit of writing. Those are actually superfluous. They do not add to the will. They are only a reason for execution of a will, which has become a norm. But actually, there's no meaning for that. Now, please, can you, section 82 is an important section. Lots of lawyers and judges have a habit of trying to assign a meaning to a will by saying that this is what he meant and this is what he did not mean. Now, section 82 is a clear indication of meaning of clause to be collected from the entire will. Meaning thereby, if you are trying to interpret a provision in a will, or a clause in a will, or a word in a will, it's the entirety of the instrument. And all its parts are to be constructed with reference to each other. So it's not as if you'll pick up one word from somewhere and word from somewhere. It's the entirety of the will which will matter. You cannot, so this is section 82. This is again a section which it has to be used both by lawyers as well as this thing when they are arguing for or against a proposition. Then we come to section 83.
So,
when made, words may be understood in restricted sense and when in sense wider than usual. Now, this is another indicator or a warning to both lawyers and to judges how to interpret a will. When to use a word in a restricted sense and when to use it in a wider sense. So the general words may be understood in a restricted sense, where it may be collected from the will that the testator meant to use them in a restricted sense. Words may be understood in a wider sense than that which are usually bare, where it may be collected from the other words that the will that the testator meant to use them in a much wider sense. Now, 83 and 82 have to be read together. A small request and an advice to you. 82 is saying the entire will has to be read. 83 is saying how you will read a particular word in a restricted sense and how you will read a particular word in a wider sense. So the interpretation is left to you as well. Yes, anything? Somebody was saying something?
no, sir.
Okay. Now come to 84.
So,
Now see this. See, these are all general principles of interpretation and construction, but they are all contained in the Indian Succession Act. There are lots of these are all where two possible constructions preferred. What will you do? The former will be preferred or the latter. It says the former will be preferred. I hope that's clear. Now we come to 85. No part is to be rejected if it can be reasonably construed. If there is something in the will which is absolutely ridiculous, you will reject it. But if it is capable of understanding and a reasonable construction can be assigned, you cannot discard that, as you are not giving meaning to a will. You are interpreting a will and you are not substituting your own understanding of the will. It is the person who executed the will whose will must prevail, whose wish must prevail. As judges and lawyers, we have no right to put in our interpretation or to try and interpret what the man meant. The only part is no part if it can be reasonably construed. Then you will go in this manner. It's not that you will discard it. You will first make an attempt under section starting from 82 to 83 to 84 to 85, and then only will you come to this conclusion, because 87 will give you the reason. Testator's intention to be effectuated as far as possible. The intention of the testator shall not be set aside because it cannot take effect to the full extent, but effect is to be given to it as far as possible. So, as lawyers and judges, it is no part of our duty to try and second guess what the testator meant. We have to go as it is, insofar as it is practicable. But yes, if not, then obviously there'll be certain terms and conditions you'll read in the illustrations. I don't want to take you right now to the illustrations because I think you're more or less familiar with it. Why I wanted to go through these sections is these are the basic principles of exercise of jurisdiction by a court. And somehow they always get lost in our general understanding or general perception of our power. Now please come to 88. There's another very interesting section, which though part of your general exercise of jurisdiction, where two clauses or gifts in a will are irreconcilable, so that they cannot possibly stand together, the last shall prevail. I don't know if any of you has ever come across such a situation. I did it once, and then I used section 88 to affirm the last part of it. So this, where they appear to be irreconcilable, sometimes people tend to confuse the issue when they try to micromanage their estate and try to take it to an extent that I must manage everything, and eventually it comes out to be that it's not possible. So therefore, the act gives you the discretion to go with the last one and not with the first one, or don't try and explain it. This is a small request. This is basically I've taken you through the Succession Act. Now, a question comes, and comes many times, that if there is a will, can you take a succession certificate with respect to accounts, etc.? If it is a will, if you go to section 370 of the Indian Succession Act,
so
it is specifically excluded. Which is required by 212, 213 to be established by letters of administration or probate. But the question comes in Punjab, probate will not apply. So will it apply to immovable property? So please read 370 carefully. We do not need a probate in Punjab. Shall not be granted under this part with respect to any debt or security to which a right is required by 212 and 2 established by letters of administration. So this applies only to debt and security, means accounts. It does not apply to immovable property at all. I think that's very clear to everybody. Section 370 is the one. The word is debt and property. Since probates will not come to you, they'll come to you when you become district and session judges. So therefore, I'm not traversing that field. That's a huge field in itself. But there is one small caveat I'd like to add here. Even if you get a probate is only a certificate of the due execution of the will. It is not a certificate of the legality of the will. A person can still challenge it on the ground that he did not have the power to execute the will. So it's not as if the probate is also the last word. Therefore, it's better like in Punjab that we go straight for the suit. Now there's one more provision where you can execute a will. That is under section 30 of the Hindu Succession Act. Hindu Succession Act normally dealt with properties which came from father to son, either copasnary or ancestral. But it for the first time granted a right to a Hindu to dispose of by will property capable of being disposed of. So this would include, as per the explanation, including his interest in Mitaksha Kopasnari. So therefore, it will only be to the extent. So even if he is the Karta of a HUF or a member of the Kopasnari, at the most, he can only will away his rights. This was a big departure actually from the normal rule that where it was ancestral property, you could not, that was our customary law. You could not execute a will. It could not go by will because everybody had a right on the date of his birth, and that right increased or decreased with birth and death. But this is one exception on which still the debate continues, and the Supreme Court has settled it many times, but somehow or the other it still continues. So this is one more provision under which you have a right to execute a will. Now, can I, if you can all have your questions ready on that, in the meanwhile, I'll just take you to the Evidence Act. Quickly, you're all aware of section 69, 68 and 69, how to prove a will, but I'll still... why is a will required to be proved? It's section 68. If a document is required by law to be attested, it shall be used as evidence until, it shall not be used, until one attesting witness at least has been called for the purpose of proving its execution. If there be an attesting witness alive and subject to the process of the court and capable of giving evidence. Now, the law says only one attesting witness, but as lawyers, we insist on producing all of them. We also insist on producing the scribe. We also insist on producing the person who purchased, from where I purchased the paper, if it's on a stamp paper. We also insist on producing the register in which that paper is entered, that purchased for execution of a will. We also insist on producing the registrar. We also insist on producing the registrar's clerk. We also insist on the registrar's, the copy from the registrar. So actually the Evidence Act does not talk of all this. But this is because of the inherent insecurities in the system, or call it the inherent what would I say, inconsistencies in dispensation of justice, that in one particular set of facts, the trial court accepts a will, and on that very fact, the district court discards it, the high court passes another order, and the Supreme Court a fourth order. So what the lawyer does, he tries and puts in everything possible, though Section 68 only requires this. It requires nothing more. And the attesting witness has to depose in terms of Section 63, nothing more. Now, I think we needn't go into all this proof of when no attesting witness found, admission of execution of party to attested documents, proof when attesting witness denies execution. These are all sections I think you're all aware of. You do this work every day. And then comparison of signatures is Section 73 in this very act. But normally the order gets passed under the CPC. Nobody refers to Section 73. And along with that, we have Section 44, that sometimes somebody does refer to it, opinion of experts. Section 45.
So
basically, proof of a will is in Section 68. Now coming to who is to prove the execution of the will. It's almost always very clear that the person who propounds the will has to prove the will. So whether it is the defendant or the claimant, it is or the plaintiff, he has to prove the execution of the will, that it was executed in accordance with Section 68 of the Indian Succession Act, and he has to prove that in accordance with the Indian Evidence Act 1872. The Evidence Act only lays down a minimum criteria of proof. Therefore, it is for this reason that as lawyers and we end up producing so many other things, not just this, because you never know, one honorable judge may say, okay, one witness is not enough. This seems to be a little doubtful, so you put in the second one. Then he may still say it's still not very evident, so you put in the scribe. Then you get the registers, and then you get the Registration Act. So all these documents together help to discharge the burden of execution of the will. Only that the will has been executed in accordance with provisions of the Indian Succession Act and proved to have been so executed in accordance with proof of the Evidence Act. Now the question that arises, if that is so, then why isn't it decreed? Why aren't all wills decreed if a person comes in? Now the law is very clear that you may prove execution of a will, but eventually you have to dispel any suspicion arising around the execution of the will. Now that suspicion will be fraud, coercion, undue influence, and various other factors like beneficiary participating, beneficiary not able to explain how he came in possession of the will, exclusion of class 1 heirs, exclusion of minors, exclusion of wife, exclusion of daughters, and there are 101 circumstances. Maybe that you got the lambardar from this village, whereas the person was residing in another village, nobody knew it. You got the sarpanch. So there are 101 circumstances which I can keep on delimiting, and we can continue for the entire day. But no one, in my opinion, and that is the law, no one circumstance is sufficient to discard a will. It is this bouquet of circumstances which, when read together, will enable you as a judge to say that the suspicious circumstances pervading the execution of the will do not enable me to uphold the will even if its execution has been proved. I am not bound merely because execution has been proved to accept a will and close my eyes to suspicious circumstances. Now, merely because a daughter has been disowned is not a circumstance sufficient. It is one circumstance. Similarly with a wife, similarly with children. But normally in courts, we always take it as a serious circumstance, particularly if there's no explanation. If there's no explanation, then almost as a matter of rule, we raise a serious doubt on the execution of the will. If there's an explanation, then it was for this reason that I read out to you those sections of the Succession Act, that you are not to put in your thought process. You've got to examine the entire will, look at the sections, go through them, and then come to a conclusion in accordance with the provisions of the Succession Act. What we tend to do is we tend to say daughters excluded, no reason given, will set aside, and maybe one other reason or something. But please, my request to all of you is, please look at the provisions of the Indian Succession Act, those section 68 and all, which I had requested you to, which I read out purposely for this reason. 71, 74, all those sections which are there. Those are very important sections, but somehow get ignored or nobody pays sufficient attention to them. Now, an important fact which is this thing, that a will does not require registration. There is no provision in any law that mandates the registration of a will. I can, if I feel like, I can just on a plain simple paper, I can get it typed, I can write it in my handwriting. A handwritten will is also called a holographic will. The one which I write on my own hand is called a holographic will. Now I'll just take you to the Registration Act. A will is presented under section 40 to the registrar.
So it's on the screen.
So it's presented there, and then there's a complete procedure prescribed of photographing the people. Each state has its own procedure. Punjab has a different procedure, Haryana has a different procedure. So luckily you don't get transferred from one state to the other, so that procedure for you is consistent always. And then there is also a deposit of title of wills in section 41 and 42, which remains with him, and it is to be given only after the person dies. So there are two circumstances. Then there's also a provision for registration of a will after the death of the testator. It's not necessary that it has to be registered. It can be registered even after death. So please look at these provisions. They are all there with you. And everything is contained in this. Now I think I've quickly rushed through everything, but the basic Bible of proof of will is one judgment, and I generally do not go beyond that judgment. It's a very old judgment, but basic judgment, and I think all of you have been taught that judgment. It is AIR 1959 Supreme Court. Can you just put up the page?
So there it is.
So in my opinion, please don't, you can keep on supplementing this judgment with any amount, but this is the basic, I would say, the Bible, the Quran, the Gita, or whatever it is, of proof of will, onus of will, and this has been followed consistently. Is 1959. How many years? You can calculate. So this is one judgment which holds the feast today, holds the field even today, despite passage of so many years. This is the judgment which started basically held that onus is on the propounder, and it is for the propounder to dispel all suspicious circumstances. I have seen judgments where honorable judges have held that the plaintiff or the defendant has not raised any plea that there are any suspicious circumstances. and therefore, because he may not have proved lack of suspicious circumstances, therefore I decree the suit. Remember, you are the one who is decreeing a suit. You have to decide everything. You have to ensure that all suspicious circumstances, whether pointed out by the plaintiff or the defendant or not, are dispelled. Suppose there's a will to you in which there's a will and it's duly proved, but the entire property has been given to a stranger, and that plea is not raised by the plaintiff. Will you say, okay, proved, witnesses have come, everything done, therefore he never said that this is a suspicious circumstance? I will not. No, you will not. You will. It's your job. If you look at the sections I've referred to, it's your job to ensure that these suspicious circumstances are dispelled by the propounder of the will. Pleadings are important, but here, when the onus is squarely placed upon the person, OPD or OPR, if you know, actually, I think in will it should always be OPP with propounder written, not with just OPP. So therefore, and there are a couple of other judgments, if you can just put them up. A few,
So
you're all aware of these judgments. If anyone wants any more, there's a whole compilation available. We can give you any amount you want to, but I thought it'd be better if we just confine it to basic fundamentals. And I'll be wrapping up just now in 2 minutes. Those other three judgments, can you just put them up?
So 1991.
Yeah, 1990 in bracket 1, Supreme Court cases 266.
And the third one that you had asked, sir, that was this one.
Yeah, please have a look at these. 7168 used in this case cannot be invoked as substitute mandatory requirement 68. Now, please look at this judgment. A very interesting judgment. I won't like to take you through it, but it's a very interesting judgment on section 71, which I just read to you. That is section 71 of the Evidence Act. So the attempt was to, instead of attesting witnesses, to come through the framework of section 71. Therefore, one seat failure or deficiency, please look at all this. It's a very detailed judgment and takes everything forward. So after this, we can start if there are any questions.
So should we open the question, sir?
Yeah, please.
Just I will just stop sharing my screen and so first of all, thank you so much. And like you were saying that it is it's really difficult because you can't get the sense of your audience if they are understanding, if they have questions, and you have to wait for the last. And I think
actually a small suggestion to you all.
Sir.
Like they're doing in IPL, they have that artificial laughter. No, you can also have that.
I think I can do that. The real one. But
every
I understand.
Evening you have artificial.
Yeah. No, I was watching that yesterday, and I realized that there's no one in the stadium, and there was still laughter going on. Now I understand it's the artificial one. But no, so I understand, because this is so difficult to. It's like talking to yourself without knowing that how things are going on. But I think we are now in the best part of our session. That is, we already have questions. So I will start with that, sir. So a lot of greetings from a lot of members for you. So I will just keep it for the last. I will start with the question. First question that we have is, if a Hindu female has executed a will in favor of A before marriage and mentioned that A would inherit all the properties acquired by her in the future also, then is it necessary for her to execute fresh will after getting married?
Just a minute. Okay. I don't understand the context of this question. Is there any law? And I'll ask the person who's asked the question also. Is there any law which there's a prohibition on a woman executing a will before marriage, or requiring her to revisit her will after marriage? The answer is in the question. Whoever is put up, just ask him to see.
I think,
That's the
sir,
disadvantage of.
the member is hearing you, sir, and there's an option the person can ask, a
Yeah,
following
he can.
question with this.
Ask
So,
him,
yeah.
ask him. Because there is,
Sure.
see, those provisions are now all redundant. We had read one part which I told you is absolutely redundant regarding women. No longer
Yes.
is that provision
I'll just.
actually valid. It's totally, there's that, which provision is he referring to? I just read it sometime back also.
Yeah, I remember. That was 59, section 59, explanation 1. A married woman may dispose by will of any property which she could alienate by her own acting during her life. Is that the one, sir?
Yeah. So here it is. The answer is right here.
So, 59 of
This is about a
negates.
married woman. So her property, she does not have to. Every person of sound mind, it says person of sound mind, not being a minor, may dispose of his property by will. His has to be read as her also. A married woman may dispose by will, dispose of should be there, any property which she could alienate by her own act during her life. That's all. No longer does a woman have a limited estate. These laws or these concepts or these perceptions arose when a daughter had a limited estate and after marriage, she lost all rights in her paternal property. As far as private property is concerned, there was no law that a woman could not hold private property. It was only that if she got it from a father or from a this thing, then she could not do it. That's all. But even that has changed now. Next
So,
question.
we're talking about section 57 in respect to probate. It
Yes.
says the probate is required only for presidency towns of Bombay, Calcutta, and Madras. But what is
Yeah.
the situation if a person files a complaint in Haryana on the basis of a will in relation to the property situated in Haryana and at the same time includes the property situated at Bombay in the very suit or the application? Is he
Then
required
you
to
will
probate or for the will?
then please read this section itself. Light on, light. If any part of the property is situated within any presidency town, then he will have to go and seek a probate. Then he will have to seek a. Can you hear me?
Yes, sir. Yes, sir. We can
Am
hear
I
you, sir.
audible?
Yes,
Can
sir.
I just read out the provision of section 57? Can you
So
just put it up?
I can put it up, sir. I'll just put it up on my screen. Just a minute. Just a minute. Sharing my screen.
B.
So, 57.
57B.
So there
B.
it is. To all such wills and codicils made outside those territories and limits so far as relates to immovable property situates within those territories or limits.
Now, this does not talk about the place of suing. This talks about the necessity of a probate. If a will is to be probated, then the suit will not be maintainable. So the question then will arise under the CPC, where will you go? So if the property is situated in Punjab, no probate. If situated in Punjab and Chennai, then you will require a probate. But where you will go will depend on the CPC, the provisions relating to cause of action, property situated, etc., etc. So in that situation, preferably what as lawyers, I mean, I can tell you from experience, what we would do is we would file it in the High Court straight. And though it's concurrent jurisdiction of the district and session judge and the High Court, but we would file it in the High Court straight. And so then lawyers would not object because the other lawyer would also have an economic stake in the case.
So,
Next question.
so we publish this question. Next question is Is the notarized copy of the probate is sufficient to prove the testator's intention?
Pardon, your voice was cracking up.
Sir, could you hear me now?
Yeah.
I was saying that is the notarized copy of the probate is sufficient to prove the testator's intentions?
No. See, in a probate, there is a specific, there's a whole chapter relating to probate. I did not purposely read it because generally we are not here. There's a chapter completely. You have to produce the original will, file it over there. I can just, and there are High Court rules and orders pertaining to probate. Both the witnesses have to submit a testimonial also before the court. I can just 1 minute. You can have a look at it later on. I can send it to you. I will give you the entire thing. But notarized copy, no. The original has to be filed.
Okay. So that answers the
Because
question.
probate is granted of an original. Now, please try and understand the word probate. Probate is not like a decree. It's not like a declaration or a decree or an injunction. It is, you are granting the right to execute that document, carry it forward. Probate is defined there. It gives you a right to collect the properties, distribute them. The executor who will be appointed or not, or the beneficiary can go to court, prove the will, and then he has the right to distribute the bequest in favor of everybody, whoever are the beneficiaries. So it is not like a decree as such, but still, it is still open to challenge on the question of title. Everybody must remember, a probate is only a proof of a will. It's not a proof of title. Somebody can come to court and say this is HUF property. He had no right to execute it. He had only 1/6 share, so the will apply to 1/6 only. Or that before that he had already sold the property, therefore no question. Or he had mortgaged it, or the various other factors.
So
next question.
So the question is now about if the will is in, can the will be executed in India regarding the property which is situated outside India?
Yes, there's no prohibition.
Okay, and the vice versa, sir?
I don't know what the American law is. Unless one of them knows it.
Sure.
Because then you have to seek probate over there.
Yes.
But I know of a case of a letters of administration issued with respect to persons residing in India,
okay,
whose father had made a trust in England for them, and they were getting money, annuity, and they're still getting annuities from there. So everything is it depends on what laws are there in that country.
Laid down, yes. So. Now, sir, the question about sometimes in court, attesting witnesses identifies their signature. They say that yes, these are my signature, but they denied having the knowledge of contents or state that the testator has not signed in their presence. Or sometimes attesting witnesses are won over by the opposite party. Then how to appreciate the evidence? Should the court intervene and ask questions?
The court always has a right, please read the CPC, etc., to address questions on any question that it seeks for satisfaction and to be able to arrive at a correct conclusion. The only question is you've got to write reasons as to why you are proceeding on that course. As far as witnesses resiling, there's a very simple method. Once he says it's my signatures, then I think as a court, it's your duty bound to ask him that why did you sign then? Problem is nobody asks him about that. You let him get away because invariably the lawyer also starts shouting and screaming. Both lawyers start shouting and screaming. So you let them get away. And then here is the provision. 1 minute. I can just take you to Evidence Act. It's after 68. Section 71. I just gave you a judgment. The third judgment includes section 71. if the attesting witness denies or does not recollect the execution of the document, its execution may be proved by other evidence. Can you just put up section 71?
So, just a minute, I think my screen is not being shared.
See, and a small request to everybody that though it's almost advised to you when you become judges that you just sit there to decide what the lawyers bring before you, but eventually you are doing justice. The lawyer is not doing justice.
So it's on the screen now.
Evidence Act. Sorry.
Oh, sorry, sir.
So you have to be proactive. By proactive, I don't mean take sides. The difficulty arises when you adopt a particular course without recording reasons.
There we have it, sir.
I just had a matter as a lawyer, and I can give you an example. Other day from Delhi in the Supreme Court, where the judge had decided to pass a preliminary decree. Now he passed an order saying, since there is no tenable dispute, I am adjourning it to enable parties to address arguments on whether I should or should not. Now that tenable dispute part, he had not recorded any reasons. So we are back now before the magistrate to record those tenable reasons. So when you adopt a course, please ensure that you adopt reasons. I know you are under serious pressure. There is lack of time. There is so much else to do. But when you adopt a course where you are going forward to do something on your own and not the normal thing, please record some reasons for that. Now here 71 is something. Can you just read where is 71 gone?
I'll just, yeah, I just wanted to increase the text and yeah, there it is now, sir.
Now, if the attesting witness denies or does not recollect the election or execution of the document, so therefore you will pass an order in this to this effect. Now, other evidence that is for the lawyer or the party to produce and satisfy you by other evidence. What that other evidence is would vary from case to case. Please study that judgment, the third judgment which Mr. Gill had put up.
So that is this one.
71 is there.
That is this. That is this judgment, sir.
Yeah. And read section 70 along with it also.
So
now, I'd like to say something on section 70. 70 says if he admits it, it's admission of the execution of the document. Correct? But this is not enough because he's required to dispel suspicious circumstances also. So you just can't use 70 and then say okay and then discard everything else. The onus is on him. Next, any other question?
Sir, we have a lot of questions actually.
Oh God. I'm in trouble.
So first of all, I don't think so you're in trouble, sir, because there are a lot of, I think, before we go ahead with this, I think I should be mentioning it. This is a message from Vineet Narang sir, who's a CGM at Banala. First of all, before he asks his question, he has conveys his high regards to you. Now, the question that he has put in is a confusion between a will and a dying declaration. And sir has also given a scenario for this. The scenario is that the person committed suicide by shooting himself. Before doing so, he wrote that he doesn't want to give any of his property or immovable property to his disobedient son and daughter-in-law. He writes that all his movable property should be given to his wife. He also writes that his daughter-in-law should be made responsible for this act of his suicide. Now the same question that I said in the starting, can this be classified as a will as nobody was there when he wrote it and then committed suicide? Or would this be considered as a simple dying declaration?
You see, it's a simple dying declaration. So, as you are all well aware, and I have reiterated today. I have not invented the wheel. You are all aware of this law. It requires two things. One, the testator himself. Now, until unless he got those two witnesses there also and put the gun on their ears also and told them, please sign, I'm going to shoot myself. So then only it would be there. Na? There's no attesting witness. So if the attesting witnesses are still alive also, he didn't shoot them also. Actually, there's no attesting witness. So it can't be, it will eventually also be determined whether it's a dying declaration because he made it. I don't know what was his state of mind also. Anybody, in my opinion, I mean, sorry, this is my opinion, and I can stand by it and argue with you, with anybody who can test it, that anybody who's going to commit suicide is not in his right mind. So there's no question of it being even a dying declaration as such. But yes, it can be a declaration that he has been so harassed or so this thing. It can be an abetment of suicide. It can't be a dying declaration as such. It's an abetment of suicide, loosely for the purpose of Mr. Arnab Goswami's television debate. You can say it in that way.
Oh, so no.
And I'm quite sure this is not that. So we will confine it to a. It can't be a will, no attesting witnesses.
So, another question: whether it is mandatory that the will should have been attested by two witnesses when the will. Okay, it's an incomplete question. Let me read it again. It's in two parts. So it says whether if it is mandatory to join two witnesses in the will when it is a wish of the testator, and second, which one will prevail out of the will and codicil, or both will be seen at the time of appreciation of will.
There's slight confusion in the question.
So maybe I can read it again, or
can you just read it again?
Sir. Now the first part of the question. So there are two parts of the question. The first part says, is it mandatory to join two witnesses in the will when it is a wish of the testator? That's the first part.
I'll keep answering one by one.
Okay,
two witnesses, yes. Mandatory two or more. The law prescribes for two or more. Section 63. Now, next part.
Next part says which one will prevail out of will and codicil, or both will be seen at the time of appreciation of the will.
See, a codicil I had explained to you is defined in section 2. Sorry, codicil. Codicil is in 2B of the Indian Succession Act. Means an instrument made in relation to a will and explaining, altering, or adding to the dispositions, and shall be deemed to form part of the will.
The will.
If you can just put it up quickly, if it's possible. We have that 2B.
Just doing that.
And it need not be that the same witnesses have to come for the codicil.
So it's on.
They can be separate witnesses. It's like an amendment, an addition, or a whatever you can say. Because till the time the testator does not pass away, he is free to deal with his property. Though people may say that while making the codicil, there was undue influence, pressure on him, etc., etc. That's a separate part. But codicil is an instrument, and which actually your second part of the question or third part is right. Whether it has been validly executed, it also has to be proved as a will, in the same manner as a will. So whether you accept it or not, that will depend upon the Honorable Judge's his discretion and the exercise of powers in accordance with the Succession Act, those sections which I have read out to you, and the Evidence Act. Next question.
So let me just publish this one. Yep. Moving to the next one quickly. This question is from Neeraj Goel sir, who's very active in all the webinars. So I expect his name, sir's name, to be there in all the questions answer round. So sir has said that we talked about the concept of privilege wills, which was incorporated by the Britishers, as their soldiers used to be in India and their family used to be in England. Does it mean that privilege wills are not recognized in these days? What if a person
Absolutely
executes?
recognized.
Yeah.
I'm only giving Mr. Goel the historical concept. If he doesn't like history, I'll delete it. Because I am a big fan of history. When I read provisions, I go to the historical basis for a particular provision. It's easier to understand. Even today in the army, they have wills which are attested by the commanding officer. All officers execute will moment they come into the army, and then they can keep on changing them whenever they feel like. But that
Yes.
does not prohibit them from executing unprivileged wills also.
Okay. And now we have a following question.
I can give him a little bit of history also. Give us a little bit of more history.
Sir.
Why the British put in all these provisions? This Indian Succession Act came in 1925, but they
Yes.
actually started this process in the 1850s. When the British came to India in the 1700s, the concept of this great white man was not there, because India was a country which was far advanced than the British itself and had more money also. So lots of these people who came in married Indian women. So they invariably ended up having two families, one in India and one in England, or they had a family in India. So when the British started looking at all this, they realized that a lot of their white men, I would say, were becoming Indianized. So if you go through the history, and if you go through a lot of these what's it called district gazetteers, you'll find all these starting from the 1850s. After 1857, when India was brought under the British, that's the time the call it the Britishization of Indian polity and of Indian this thing began, and even the army. Earlier it was, if you remember, it was the East India Company.
Yes.
England was not here that time. They had a charter to trade in this country and they became rulers. So, Mr. Goyal, a little bit of history is not bad.
I am sure Mr. Goel understands, and that's why he has a following question onto the same question that he asked. The following question is: if a person has prepared a privileged will and retires from service and does after 5 years from the date of his retirement, can still his privilege will be acted upon, which is neither not signed by the testator or is not attested?
Yes, it will be. It will be. It will be. That's the simple answer to it.
And how can he prove it, sir?
It's because it's see the act, na? Ask him to read the sections of privileged will.
Okay.
Because see, we are not dealing with today's times where connectivity. Here you're dealing with people who went into the armed forces and were not seen or heard of for years together. So you have to, it's always, everything is in the context of a particular thing. It will continue to apply till he doesn't alter it. It's like a, very loosely put, like a nomination.
So,
for your account, for your LIC.
So
yes. Anything else, Mr. Goel?
I think sir will.
The part is I can't see anybody. That's always the problem with all.
I know. It has a two-edged sword. We have a pros and cons. We can address a larger audience in one go, but with the this thing that we cannot see them. So move to the next one. The question is now about again the will. Both the executing witness of registered will are dead, and their family are in abroad and are not ready to appear in the court, not even through video conferencing. Then how a court should appreciate the will?
See, first, the onus to prove the will is not on the court. The onus to prove the will is on the person who propounds the will. If no witnesses can be found, obviously you will have to prove his signatures. Now, if you can't find, if the relatives are not ready to come and acknowledge the signatures or even on video conferencing, then there are other means of proving it. You can get where he was working. If it's in the bank, there might be an account where he was working. He may have signed something. I mean, I don't think there's anybody in this world who would not have worked somewhere or the other, or would not have affixed. Even a farmer affixes his thumb impression at the time of taking his crop from the art, bringing his crop to the Artiya's place. When he gets his MSP, he puts his. So it's they'll be available. This is for the something will be available. That's what it says, na section 71 and all these things. You can. It's up to you. Any amount of evidence can be led. It can't be put into a cast iron. So if you can't prove it, so go ahead with it. That's
So,
all. Now, if tomorrow you will say even there's no court, then what? How will you prove it?
so the next question says, if will is with regards to debt and securities, and also other movable and immovable properties, then in such a case, can a succession certificate still be issued for debts and securities?
Should not be. Court should desist from doing it. They should ask them to go and file a declaration, because if you see, I read out section 2.1. What was it?
2A.
Section to you 270. What was it? What was it?
That was 370 and 213. Which one?
But 370.
370.
And if you can just put it up.
I'll do that, sir. Just give me a quick moment.
But in Punjab and Haryana,
so 370 of Indian Succession Act, right?
Yes, but in Punjab and Haryana, since you do not require a probate, so the court can, after recording satisfaction or recording an order that this is only for the purpose of a succession certificate, and a succession certificate is not a regular adjudication of a will, it's only as a summary execution. Therefore, you can issue succession certificate for part of the property regarding bank, etc. But you cannot issue for immovable property, and a declaration of a succession certificate, even if there is a will not affirm the will.
Yeah, there it is. And 370.
370.
Yeah, it's taking some time.
Shall not be granted under this part with respect to any debt or security to which a right is required by 2.1.2.1.3. That is probate and letters of administration. So since we do not have probate and letters of administration in Punjab, you can do it, but you will have to record that this is only a summary procedure. There's not proof of the will. This is subject to the parties' rights to establish to the contrary in a regular suit.
I think because the way you are taking this webinar, in a different format altogether, because with everything that we are talking about, you're just taking everyone back to the acts, back to the sections and specific sections. I think I've got so many regards, comments on this, that it's really important. It's really helpful, because rather than talking in the air with experience, you're taking them back to the basics, and I think that's what is the beauty of this session.
I think that is most important, because as judges we all tend to forget fundamental law and we go on perceptions, and sometimes our perceptions are wrong. There's no doubt. That is where lawyers come in.
So, and that's what Jasmine ma'am from Jalandhar said, the same thing, that this webinar is very helpful in the sense that it has saved us from referring a plethora of case laws and statutory provisions.
You'll come to any, even the ones which are available, I've done with lawyers. First thing I always excuse myself is that I am not a judgment bound judge. Judgments are crutches which we as judges and lawyers use. Substantive law is clear. There's no point. This is my opinion. I don't know. I may be entirely wrong.
So I think I'll move to the next one. The question is about if is beneficiary acting as a testing witness a circumstance to discard the will?
Like I said, there is no circumstance sufficient to discard a will. It will all depend on the facts and circumstances as to what extent did the beneficiary who was present during the execution of the will interfere with the free will of the testator. So it's not as if, and there's a provision regarding that also. Come to section 67. Can you put it? It's a very interesting section.
67, sir,
of the Indian Succession Act, which we all tend to actually ignore. Even I ignored it. I also read it yesterday when I was trying to refresh my memory on this.
I'll just do it. 67. Act itself. '67. So here it is on the screen now.
Now, this is not exactly answering the question, but this is something where you can take guidance from. That it is not everything. A will shall not be deemed to be insufficiently attested by reason of any benefit thereby given either by way of bequest or by way of appointment to any person attesting it, or his or her wife or husband. But the bequest or appointment shall be void so far as it concerns the person so attesting, or wife or husband of such person, or any person claiming under either of them. Now, please, sorry, there's not a live audience. I would ask somebody to explain this on a typed answer.
I will just, I think
I'm actually a little mystified by this section. I mean, I honestly admit it, because the first part seems to say no, second part, yes, second part says no.
I think even if the questions will come, I have to leave the screen and then see the questions if they're coming over there. So I think probably we'll, by the time
I'll put this up to everybody to explain. This is call it now the interactive. So if anybody can explain 67, okay. Please. And the question is, no one circumstance is sufficient to discard a will. It's always call it the bouquet. You want, bouquet is not the right word to use, but it's various factors combined together. Whenever you write a judgment on a will, and if you're discarding it, please don't say, okay, this is sufficient to discard the will. First, set out all the circumstances which you feel are suspicious. Why are they suspicious? And then after that, say that, therefore, taking all these together, I feel this is a will which is suspicious. And you've got to remember, there's one small thing you need to remember. Suspicion is the word here. It doesn't say that you have to prove it to be, that it has to be proved to be illegal. There's a big distinction between suspicion and proof. But at the same time, there's a difference between perception and suspicion. Perception is what happens in TV debates in the evening. I hope you got my point. Yes, suspicion is what happens in the newspapers, and proof is what happens in the courts. I hope everybody's got the difference between the three things. So you are somewhere in between. You are somewhere in between. So it's suspicion. You can't have complete proof as to what happened when the person was attesting his will. Who was there, who was not there. This is all suspicious circumstances. The word is suspicious circumstances. So I think if somebody has managed to explain 67, we can go to there, or we can move to the next one.
Oh, sorry. Right now we don't have any explanation, but as and when it comes, I will just put it up. Okay. Moving to the next one. So remember, we in the starting we had the first question about marriage of a woman and the will that she has done before marriage, will it be applicable after marriage as well? When we ask
Yes,
the
yes.
members to have the give the clarification on it. I've got the
Yeah, yeah.
clarification on it.
What does he say?
So now it says that it's not about marriage of a woman. The question really was whether a woman through a will can dispose of a property which she still has to acquire, own, or possess.
That's a googly or something.
So basically, it's we were thinking that the question was about what she has.
1 minute, 1 minute. Please let me take him back to what is a will. Can you just take me back to will?
So could you please let me know the section
2H.
number?
2H.
2H. So just a minute.
This is my answer. The gentleman concerned is welcome to answer it in whatever way he feels like. But my answer arises from 2H. And
there we are. So on the screen now.
H. Will means the legal declaration of the intention of the testator with respect to his property. It's a property in present time.
Yes.
Or you can say property that I may acquire. In that situation, if there is a chance of an acquisition of a property, a will always have a clause saying all my properties today or any property that I may hold on the date of death. So whether it is a woman, she must be holding that property on that date.
Yes.
Until unless there are rights, there are certain rights, like suppose there's an allotment. I can give you an example. But the allotment has not fructified into a sale deed by the government department or the HUDA, PUDA, or whatever they are, those things, not been executed. Now that is a tangible right. That's a right in property. Therefore, all rights in property which or a right can be made part of it. But I don't know what right to succeed would be.
No, I think so. You answered the question because the question was about that she might possess in the future. So I think when you said about that the clause has to be made very clear in the will itself that whatever that she has right now and whatever that she possess in the future
She
would be
can
going.
say that if I inherit any other property or I acquire any other property, it will also pass. There's no prohibition in that.
So I think that that was the question. So you will, and let me see if we have got the part. We have got I think a response on section 67, like we had asked, sir.
Yeah, please.
So it says, as per section 67, other parts of will be operative. That is only bequest to attesters shall not operate.
What is the first part?
Haven't really got anything on that, sir.
No. What I'm saying is the bequest shall be illegal, but the will shall not be illegal by reason of his. A will shall not be deemed to be insufficiently attested by reason of any benefit thereby being given either by way of bequest or by way of appointment of a person attesting it so and so, so and so. But the bequest shall be illegal. Whatever has been given to him shall be illegal, but the will shall not be. So the question was, attesting witness participates, is a beneficiary. This is the answer there.
Okay.
Now, how you take it forward to meet those situations is what I'm trying to say. That's why I wanted a participatory sort of analysis by everybody, so that everybody's thinking and it's, you see, in a normal session you can point out to somebody, okay, please don't go to sleep. In this you can't even do that. All he has to do is to keep himself there and walk off.
Yeah, I know. But I
That's
think
the beauty of the webinar.
these sessions, require us to be really highly optimistic that everyone is listening. But I'm sure, so these sessions are, because these are not mandatory sessions, so members who are joining in, they're joining with full interest, and that's the reason we are still getting questions. I think I will move to the next one because the questions are still coming in. And okay, the next one is, if will is with the regards to, oh no, we have done for debt and security. The next question is, my proposition is, if a case, there are two persons who are beneficiaries in the given will, I think given will होएगा शायद, मेरे ख्याल से will गलती से हो गया, in the given will, in which one is given a right to the testator to have 20% of the sale proceeds in case a second beneficiary sells his property. So this is a scenario. Now the question is whether the first beneficiary could be able to enforce his right against the second beneficiary in the court of law for making him sell the property eventually to the effectuate his own right, and secondly, whether the first beneficiary would also be required to prove the execution of the will in the said case for both the parties. I will admit the execution of the said will, now it is incomplete. Yeah, that's so the last question was that would also be required to prove the first beneficiary would also be required to prove the execution of the will in the said case for both the
I
parties.
can start with the last question first.
Sir.
Anybody who seeks any benefit under any will as a beneficiary or as an executor of the will is required to prove the will. Whether his benefit arises after another beneficiary sells the property or after the other beneficiary gets the property. There can be a case also where the property is in litigation. And as of date, a decree has been passed against the rights of the person who's made the will. So there are many situations. The beauty of the law and the economics of the profession for lawyers is that you can have any amount of situations anywhere. So that is the situation. Now, as regards whether he can go to court, he can, yes, go to court and say that he should be directed that first of all will. Now, in such situations, normally in our part of the country, we don't appoint an executor because probate is not necessary. This normally happens as a letter of administration. Actually, this is part of leisure of where you have to collect things for the property, or you have to dispose of properties and then give it to the beneficiaries. So since we don't have that, he has been conferred a right under the will. So he can go to court to enforce his right. But the only question that will arise is whether the other person will first of all accept the will. Two, if he doesn't accept the will, then he doesn't have a right. He loses his benefit. So I think that last part was that will admitted. So once what happens is, so the court will decide the rights of both parties. And that party will take that property, that caveat on the right to receive the property will remain. Meaning thereby, if there is no schedule for sale, then as and when he sells. So he cannot sell the property without giving 20% share to this gentleman. Now the question arises, can he go and enforce that right? In my opinion, he can. There is no prohibition in the Indian Succession Act or in any other act because it's a right in law. And he becomes a co-sharer to the extent of valuation of the property. In my opinion, there can be no prohibition on that. At least until somebody points out some provision to me. I mean, I have not come across any. Until unless the gentleman who asked the question knows it, he can make me also wiser. I also learn every day.
Certainly, sir.
I am not the repository of all knowledge.
I think so. I think I heard it somewhere, that people who wear white coat and black coats, they cannot say that they know it all. Because
I always maintain and always told even lawyers in my court and everywhere that the day a lawyer or a judge says that he knows it all is the day he's going to make his first biggest blunder.
So it's a living this profession is more of it changes every day. So I think what you are saying is, I think it's I think it's your wisdom, it's your acceptance that learning never stops, and I think that's what we're here for this session as well. I have an answer on 67 as well, but I will first take the question because we will otherwise be on the same topic. So the question is, if the will established in succession certificate between the same parties, shall operative res judicata in subsequent civil suit between the same parties?
No. No. Answer is no. So, because succession certificate is summary proceedings.
Okay.
Just like in probate, even a probate does not operate as res judicata. It only operates as res judicata. Probate operates as res judicata regarding execution of the will. But regarding the right to execute the will is a distinction point. This distinction. You can file a civil suit even if a probate has been granted. You can file a civil suit even if succession certificate has been granted.
Sir, a comment on 67, and then we have a last question which is left. So I'll read out what is written about 67. And it says section 67 says that the beneficiary can be a attesting witness and it's valid attestation, but the will is not valid qua the benefit testing witness gets to the will. So I think that's
so the benefit gets nullified. Benefit gets nullified, but the attestation remains valid.
Yes.
Like and suppose he says that I'm giving you a house. The house, the bequest will become invalid, but the attestation will remain valid. So that is why it's always said that if you are going to be beneficiary, go and hide behind the door of the registrar. Don't come in front. As it is these days, everybody videographs everything. So normally the beneficiary is actually right there. But he's hiding behind everybody.
That's a new perspective to look at it.
That's the truth. Ask all of them sitting there. They would. Or he's sitting at home and monitoring everything on his cell phone.
So there's a request from Jasmine ma'am that could we go through the section 84 of Indian Succession Act one more time. I will share that on the screen.
Okay. Which of two possible constructions preferred?
84, and I'll just quickly. '84. Where is 84? So it's on the screen now. So can you hear me?
Yeah, can I request everybody to try and give a response, whoever feels like? I will also give it.
Okay.
Somebody can put in an answer.
So I have to go on that screen, sir. So probably
okay, sorry.
Yeah.
Okay, I'll try it, and after that they can all. Anybody can pitch in with his. So what this means is, suppose there's a clause in a will, which is susceptible to two meanings. Now I'm not going to give you an example here, because then we'll go on and on. I think we already 1 hour and 54 minutes and 34 seconds, I think. Is that correct? So I also have a throat to take care of. And since I'm a lawyer, I don't get paid so well for webinar. I don't get paid for webinar. Sorry, please don't take that seriously, anybody.
You wanted laughter. You're getting laughter.
No, but somebody might take it seriously. They might quote me. Go and quote me somewhere. And that'll be the end of my career as a teacher.
No, sir. I'll share the also the compliment that we are receiving after the question answer is done. So I think you are you will be reassured that your teaching and your profession of a teacher has a very people want to have you over there. So
No, I'm actually humbled by all this, but I'm welcome. Anybody is welcome anytime. Can please call on me. I have no issue. I am very fond of my own voice, and this is the best forum for you to appreciate your own voice. Sorry, let's go. Let's get back to serious matters.
so
Where a clause is susceptible to two meanings, according to one of which it has some effect, meaning it has some meaning, and according to the other of which it can have none, meaning it becomes meaningless. One interpretation has some meaning which you as the judge will try and find out, and if it has no meaning, the other part, then the former shall be preferred, which has meaning.
okay.
Former means the one that comes first. Latter means the one that comes later.
Yes.
So you will prefer that. But yes, if there is no meaning at all, then you will discard that clause. So, like, let's take a clause. It says, you shall inherit this property when the sky falls on your head. Now, one part is quite okay, you shall inherit this property when the sky falls on your head. It's not possible. So, which one will you prefer? I'm requesting all the judges here to answer this now. The question is as silly as the section,
Mhm.
but there is a rationale for this section. These are all these sections which I've read out today, which actually even I did not read very often, are actually indicators on how to interpret, read, determine a will. So, anybody, any responses? See if any response.
I'll see to it, sir. Mm, to give it a minute to see if we have any response.
I think it's too late. Lunch. Everybody's been deprived of lunch.
But I think, sir, if you get anything, I'll just share it with you. Otherwise,
Please do. Because
they
see,
are.
I am as much a student of law as all the other people here, and I would like to understand how they actually they are the fighting front of the judiciary, no? The subordinate judiciary. They are the ones who are actually, and they are the ones who actually have to answer these questions also.
So, sir, as far as we were talking about, a lot of people have written everything. I think there are a couple of it which I would like to read because it is very reassuring, when we hear from our audience that they really enjoyed the session. One of I'm just going to read this one because this is, everyone has said thank you and they said, that thank you for sharing your wisdom. There are a lot of comments on those lines, but I'm just picking up one because this is very special. It says, it's really a wonderful session, my lordship, and you always like a guiding star to us.
Thank you. Thank you.
So that's I think what you were talking about. I think people liked it, people enjoy it, and I think
Thank you.
it's really important. So we are talking about that it's a lunchtime and everything. We are the receiving end. It's been 2 hours that you've been talking, and this is 2 hours on paper. But I know that you were available here at 11 o'clock. And you've been, available before the session because we were doing some testing and everything. So for you, it's 2.5 hours, and then you are the one who is talking continuously. So
yeah, it's a pleasure. I'm telling you, it's a pleasure.
but I think, sir, it's our, we can't thank you enough for sharing this information. And people are asking for citations and presentation copy. I would just like to say that this video is getting recorded. So like sir said that sir wants to, loves listening to his voice. Sir, it's now recorded. It will be it'll be on the Academy website. So the entire presentation, anyone who wants to rerun the presentation.
But please delete all the silly comments I've made.
So I think it's a part and parcel because of the session, because if he would have been just on the point.
Delete this particularly at least, or mute it at that moment.
So I'll take it offline with you on this.
Yeah, please do. Get it approved from me first. I'll
So
censor it.
I will send it to you, and you whatever that needs to be taken care of, we'll do that off. And at the end, like I said a few minutes back, this presentation would be available on the Chandigarh Judicial Academy website. So all the citations that we have cited over here are available over there. I will also, after this, after we are done with this, I will also just stick around. I will put the citation in the chat, or let me do one thing. Let me just put it right now so that there's no delay in that.
Good afternoon, Lordship. We found some very interesting judgments on some of these topics while, in fact, the session is in progress. But in
Mr.
case we
Kapoor.
start popping out, yes,
Yes, sir.
good afternoon, Lordship. In fact, I was also beneficiary. I thought before we, I think, conclude this, I'll say my personal thanks to you for coming and enlightening everyone on, I think, many points, which was, I think, a great learning for all of us. And yes, there are a few, I think, important judgments that I could find while we were listening to your thoughtful, I think, analysis on, I think, very good questions. So what we will do, me and Chetan, we will work and we will, I think, share some important judgments also, the citations also on some of these questions. We will reflect on everything, we will review and then share the citations with everyone as the notes. I'm sure this will be a very, very meaningful session. This is, I think, highly, I think, educative for all of us. Thank you so much for giving so much of your precious time and making it a very light note, I think, session for all of us.
So can I now thank everybody and switch off?
If the lunch is already served, yes.
So thank you very much for having me and bearing with me, and thanks a lot. Bye.
So,
Thank you so much, sir. Have a great day. And everyone, thank you so much for joining us. Without you, this session would have been of no sense, would have not made any sense. So thank you, everyone. And we'll see you with the next webinar. Thank you. Have a great day.
thank you.